I'm Vuzonokesi, the president of the Law Society of South Africa. I would like to brief you on the evolution of the Law Society of South Africa. Firstly, in terms of the 1934 Attorneys Act, there were four provincial law societies which existed independently from each other, those being the Cape of Good Hope, the Orange Free State, Transvaal, and Natal. This was seen as a divided profession that was not representative, that was not reflective of the demographics of the country. That led to vigorous engagement by the members of the profession, culminating in an agreement that ushered in 1998 a new era and a new constitution, whereby a unified law society was established. The constituent members of that law society were the four provincial law societies, NADEL and BLA. In terms of the objectives in the profession, that of unifying and establishing a single regulatory body, negotiation ensued, culminating in the passing of the Act. Once the LPA was passed, that led to the demise of the provincial law society, of the four statutory provincial law societies, and the profession had to engage on to what is the future of the members' interests. It was at that stage that the entire members of the profession, after having been consulted, unanimously agreed for the formation of a reconfigured Law Society of South Africa, whose members were the attorneys from the 9 provinces and BLA and Natal. In terms of the representation of non-provincial law societies, the representatives would be selected from persons who are neither BLA nor Natal, and the other members would come from BLA and Natal. This was to ensure that the profession has a single voice and it continued to play its role in terms of promoting the rule of law, constitutionalism, and the members' interest. It was on those bases that the new LSSA, that now has 27 members who sit in what is called Constituent House, where the members' interests are being deliberated. And this structure has an executive committee. The executive committee has 9 members, and that committee is led by a president with 2 vice presidents who are drawn from the constituencies who at the time are not serving as the presidents. What are the key essential differences between the LPC and the LSSA? The LSSA represents practitioners and public interest litigation. The example of those cases would be ProxySmart versus the LSSA, a judgment that was confirmed by the Supreme Court of Appeal. It is the unified voice of the legal profession. It provides a forum for practitioners to gather and deliberate. It provides legal educational training, provides practice management resources, provides legal education training and practice management resources. It provides advice, practice support, and information to legal practitioners, newsletters, notices, monthly magazines. Hence, we do have D-Repos. D-Repos is part of the LSSA functions. It lobbies government and other stakeholders, such as LPC, when there is an increase during the increase of fees. It is this body that negotiates on behalf of the attorneys. It engages government when the acts are being passed. It expresses the voice of the attorneys in relation to those acts and any other important issues, like some key governmental appointments. It comments and makes representation on issues that affect the profession and the public. It provides members benefit initiatives. Actually, the LSSA is a members interest organization although it also deals with the public interest. Whilst on one hand, the LPC, it deals with it purely represents public interests. Secondly, it regulates the legal profession. It is tasked with transformation of the legal profession and practice. It develops policies and codes of conduct for practices, discipline practitioners and practices, accreditation and monitoring of legal education and service providers. It maintains database and record of legal practitioners and practices, coordinates examinations and assessment for admission, enforces compliance with the Legal Practice Act. In actual fact, from all what I've said above, the LPC, its primary task is to regulate the profession, whilst the LSSA's primary task is to promote, protect the members' interest and the public interest. It does both members' interest and public interest. Hence, those cases that I've referred to of the proxy smart versus the Law Society of South Africa. That's a very, very important information that the legal practitioners and the members of public must be able to understand in order to draw the differences between the LSSA and the LPC, and also understand the functions of this organization. I hope that this will assist you as you seek to understand more about the regulation and the governance of the legal profession. Thank you very much.